Welcome to the Wealth Transfer Podcast, where we unpack the strategies, structures, and conversations that shape how wealth moves across generations. I'm Matt Templeton, and in each episode, I speak with the trusted professionals, from estate attorneys to transition advisors, who help families steward assets, avoid costly mistakes, and build lasting legacies. Whether you're planning your own future or you're one of the people guiding others through it, this show is your front row seat to the smart conversations around wealth transfer. Let's begin. Today's guest is one of the most respected tax attorneys in the country, Joel Crouch. He's a partner at Meadows Collier in Dallas. Joel specializes in helping wealthy individuals, families, and business owners navigate high-stakes tax planning, estate issues, and IRS controversies. He's been named a Texas Super Lawyer every year since 2003 and was recently recognized as the 2022 Tax Law Lawyer of the Year by Best Lawyers in America. And in this episode, we dive into what really happens when the IRS comes after an estate or a family, what red flags trigger audits, and the mistakes that cost families millions. You're about to get rare insight to someone who's been talking to the IRS every day of his career and who's been in the room when it matters most with the IRS. Let's dive in. So Joel, tell me about your background. You've been a tax attorney for 38 years. What does that mean?
No, don't age me too much. It's 36 years.
36 years, okay. Tell us about what that looks like and how that journey's been fighting the IRS.
It's an interesting story from the beginning because I wasn't going to law school, but my fiance wife, who was my girlfriend that became my fiance, she was going to law school. I ended up going to law school also. And then when I got to law school, I wanted to do something in the tax arena. I didn't want to do tax planning, though. And so I found this firm, which I've been through with my entire career. So I went to this firm and been doing tax. We're the only people in town that did it at the time. This was really what we did, which is our niche, was to practice in dealing with the IRS. It's an interesting practice. Anybody that deals with the government knows the government is a different animal on the other side. You can get people who are very good. You can get people that are not so good. But most of the time, you get people that are at least trying hard. It has been a challenge through the years to deal with lots of issues for clients. You do this long enough, you run into all sorts of crazy things that people do and those kinds of things. But it's always resulted in a very good practice. It's been fun. It's been interesting, which is great because you don't want to lose interest in what you're doing.
Now, you're based in Texas. I'm based in Texas. Would you have clients in other states as well? Or?
Oh, yeah. I have clients all over the country. Just because this type of practice, you can do it. I can have clients anywhere. I don't have to be admitted in that state because I'm not practicing state law. I'm practicing in front of the IRS. And so as long as I'm licensed here in Texas, I can practice anywhere. I've tried cases in Chicago. I've tried cases in Georgia. We've had cases all over the place. And I've had clients all over the country. So, yes, it's the kind that travels well.
Now, in our business, we deal with a lot of real estate transfer or sometimes estate tax or that sort of thing. What types of tax are you fighting with the IRS, or what's the purview of your business?
Well, I always say that my three areas are: one, we deal with estate and gift tax, whether it's on the front end when we're trying to get our clients in the right position with the IRS, or on the back end when the IRS has come in for an examination. I do a lot in income tax, where now the IRS is looking at something that's on an income tax return. And then third, we deal with employment tax too. We have a client, we have a business, and the business is having some sort of employment tax issue of some kind. And that's really what we do. I mean, a lot of times I tell people we deal with death and taxes. That's what we deal with on the estate side and then on the tax side. So to quote, I don't know who was that said death and taxes.
That is a famous quote.
Is that Benjamin Franklin? It may have been Benjamin Franklin.
Yeah, but we'll give it to Benjamin Franklin. Good things, death and taxes.
Yeah.
So on a day-to-day basis, a client reaches out. Are you just calling the IRS hotline and sitting on the phone for an hour?
Oh, no. We don't want to do that. No, a lot of what we do every day is we are dealing with maybe an IRS examiner. It may be somebody in the IRS Appeals office. It depends on where it is in the process. Is it an exam? Is it an IRS Appeals, which you have the right to go to after exam? Or have we filed a tax court case because we couldn't agree with the exam or appeals, and now I'm dealing with the IRS counsel at this point. We also work with the Department of Justice Tax Division on refund claims. They're the IRS attorneys when you file a refund claim that's not allowed by the IRS. Your ultimate way of resolving that is you file an action in federal district court, and then the Department of Justice comes in, and their client is the IRS. So I'll deal with any of those four, most of them every day on something, whether it's discovery, whether they're looking for documents, or whether I'm looking for information. So lots of different things. Hanging out on the phone with the IRS is not one of the things I would really enjoy.
Totally.
Well, they put on this hold music that you really don't want to listen to anyway. And it's on a loop, so nobody really wants to hear that every day.
That's so fun. What are some of those interesting things you're seeing in estate and gift tax issues with the IRS right now?
Well, right now, I mean, the hot item always is from the IRS standpoint on a state and gift. It's the one that's always, a lot of cases start with this and end with this, which is valuations. That's always a big key issue is what's the value of this asset in the estate? What's the value of this asset that's been transferred? We work a lot with appraisers. And so the question becomes, what's the value of this asset for purposes of estate or gift tax? Where you don't want to be is when they don't even get to the valuation issue where there are problems. And I end up in a lot of those cases because I get a lot of, okay, the problem, it's gone over, the CPA can't handle it anymore because they're out beyond their skis. This is not what they know. And so I'm coming in because we have problems. They haven't done what they're supposed to do on the gift. I mean, I've got lots of different stories we could talk about things that don't match each other that they should have matched, and problems here, nobody having the follow through on what they were supposed to do when it came to setting up the entities, doing what you're supposed to do with those entities. That's where you get into the real problems of the IRS. If you get to a valuation issue, that's just a question of two appraisers and the court trying to come to some sort of conclusion. The majority of my cases resolve themselves somehow. I mean, they just do.
Are you seeing that the IRS doesn't agree with the valuation, or are you seeing that maybe they didn't actually have a formal valuation made for that specific property?
You see actually two different ones. In most cases that I'm involved in, there is some sort of appraisal they've done of some kind, appraisal, valuation, whatever you want to call it. One is you will see an appraisal that probably is not as good as it should be. A lot of people go cheap on the appraisal. That's a bad idea because what you really want is you want to pay for a good appraisal, and sometimes we get what we would call a canned appraisal that just kind of throws things against the wall, see what sticks, and that's always a problem. And so what I always tell people is you want to up front get a really good appraisal because, again, you don't want to make it easy for the IRS. And then two, the question comes down to, second part of it is, let's assume you have a good appraisal. There may be a difference of opinion between the IRS appraiser and our appraiser as to what kind of valuation discounts to give. And that's really where the attack comes in. And that's when you're getting to that point of discussions, that's where you can generally reach a resolution that everybody can live with. The other thing I tell people is on appraisal is you want appraisal that somebody can stand behind, but you don't want one that you say it overstates the discounts, but you also don't want going, well, let's just understate it and maybe the IRS won't come after us. I just assume if it's a taxable estate, the IRS is going to look at it. So let's give it our best shot and let's make sure it's a good one. And let's make sure it works well and make sure we can defend it, frankly.
So in discounts, obviously that's usually on either property that's like held and hard to transfer, or maybe it's a business that, you can't quite, it's got different valuation. What are you seeing discounts for?
Well, generally you're going to get two different types of discounting because a lot of our clients, probably like many people, a lot of our clients are closely held businesses, family businesses, those kinds of things. And so you're trying to figure out what the value of a closely held or family business is. And you're going to get two different things. You're going to get a lack of marketability because somebody's buying maybe a minority interest into this company. And that's primarily the biggest one you're going to get, the lack of marketability on something like that. And you're going to see discounts, combined discounts of everything, probably up to 35%. I mean, if it's set up correctly, I've seen some in excess of 40%, but 35% is around the general area you see these days on combined discounts. And that's really where the things come out.
Now, I know a lot of estate attorneys talk about setting up entities so that they can make the property hard to transfer, hard to market. And that allows you to discount it if you're trying to take a large estate and make it, quote unquote, worth less to the IRS.
What I always tell people is don't let tax tail wag the dog. In other words, you want to set them up because it makes business sense. And one of the things you're going to need to do is make sure that you've done it in such a way that you can defend it saying this made sense from a business standpoint. We're not just doing this for tax purposes. One of the things I always tell people is at some point you're going to have to, you may have to look a judge in the eye and say, we did this because of X, Y, and Z. The tax benefits just went along with it. So don't let the tax tail wag the dog in those circumstances.
That's a great point. I assume, the IRS are real people. Do they take that into consideration? Like, oh, you were just making these choices to try to have less tax? Or do they recognize that that's an acceptable human instinct?
It all depends. What I always tell people, one of the things I have in my list of things to do is before the IRS shows up while you're doing your transaction, whatever it is. If you're making gifts, if you're setting up a family limited partnership, whatever it is, you're going to at that point put together what it is the reason that you're doing this. I'm setting this up to protect the assets from this, to protect this from this family member. I'm worried about divorces that may go on, and so I want those assets protected. I have kids and they may get divorced. I have kids that person can't handle it. Those kinds of things you need to be thinking about, papering and showing why I'm doing this, because if you don't do that and you're trying to backfill, I get a lot of cases we get involved in where I have to start backfilling what needs to be done because somebody hasn't dotted the I's across the T's, and so we're having to go back in and kind of build this back up again. And I hate to have to do that when the IRS is already there. It makes it even worse, but if we have mom and dad that are already dead, and we're trying to backfill at that point, that's not good. We need to do it while mom and dad are alive. I mean, the best client for me, it's the worst client actually for me because they're not going to hire me, but the best client is the client who has dotted those I's, tossed it across the T's, worked with their CPA, who's worked with all their professionals to make sure that planning that they did, they're doing everything they're supposed to do. Because you're too young to remember it, but there was an old commercial for Fram oil filters, and the guy would say at the end, he installed the Fram. It was a little more expensive, but you can pay me now, or you pay me later when the engine blows out. So pay me now to do it up front correctly. Don't pay me later to have to go fix the problem, which gets a lot more expensive.
That's a great point. I had an estate attorney like 10 years ago tell me the process of building your estate plan is sophistication. And he said the thing is not just entities. It actually is the documentation that helps build your sophistication. I think that's often understated when you think about like, oh, we've got our entities in place. Everything's all set up from a legal perspective. But even just the notes of here's why we did it. Here was our thought process. Here were the thinking. Like that actually creates more sophistication than you might think. And it's not as legal. It didn't feel quite as formal. The attorney may not pay the attorney to write it up, but those notes are actually what would allow you to go back and say, here's how sophisticated. And he said the sophistication starts building layers and layers of walls.
That's exactly right. It's exactly right. It's almost like putting hurdles up. It gets back to the idea that I always try to tell people, you don't want to be the low-hanging fruit at the IRS. You don't want to be the easy case for them. You want to be the case they go, oh, that's going to be too much work. You can never overstate the fact that you're going to have people at the IRS that have got a lot on their plate, and they're going to be going, okay, that's an easy case. That's a hard case. Let's go with the easy case. You want to stay away from being the easy case. You just don't want to be that, as I say, the low-hanging fruit. And the more you can do to make them have to work, the less easy you're going to be.
So I guess the easy cases for the IRS are also the ones that you have to work the hardest in. Do you have any examples from either recent years or even far back where you had something where it was hard to fight the IRS because it lacked some of the sophistication it needed?
Yeah, I can tell you one that's a perfect example of something similar to that, which was we did have somebody who did do really sophisticated tax planning, good estate planning, good stuff. The problem was there was no follow-through on it. For one, there were two sons there. We didn't tell either of the sons that we had, as part of this planning, had gifted to them a portion of these entities. In fact, when mom and dad died, they had no idea. They had created a family limited partnership. They had created a general partner who's, LLC that owned a little bit. But they had let all of those entities lag from the state. And they had not paid, had not done their filings. They had not done any of those kinds of things. The good thing was we got in before the IRS got involved. And we sat down with the two sons and said, okay, here's the deal, guys. We're going to put you in the best position we possibly can. But there's some things we can't fix. I mean, that's gone at this point. But we're going to put you in the best position. And they were great because they said, we completely understand. Mom and dad had some great ideas here, but it would have been nice if they told us about this. I mean, we got distributions coming out of the partnership in which to mom and dad, but the sons are partners also, and they're not getting any distributions. Of course, they don't know about it. I mean, all those kinds. So we're going in and fixing all things, putting the entities back in good standing. Eventually, the IRS came in after we filed the 706, looked at it, had a few questions here and there, but we had plugged enough of the holes that they kind of made a few adjustments here and there. But we were at least able to do that, pre-filing the 706, the estate tax return, so that we could kind of put it in the right position, at least. But it was one of those things that you say to the clients. You don't say this very often, from the very beginning. You say to the clients, okay, understand, we're going to put you in the best position, but we can't try this case. this case is untriable. There are just too many bad facts. Let's get you the best position we possibly can, and let's take it and go home. And they were thrilled with it at that point because they understood it completely.
Does the IRS usually attempt to settle? Is that their goal as well?
Yeah, I mean, so there's levels of the IRS. You start with an examiner. Now in the estate and gift area, you've got pretty sophisticated examiners. They're attorneys. All of them are attorneys. So you're going to get a higher level examiner than you're going to get if you're dealing with somebody on the income tax side. Those are generally maybe CPAs, maybe not, but you're going to get an attorney. So that's the thing to start with. The second thing is if you can't resolve your case with the examiner, you have a right to go to IRS appeals. And appeals has a set number. I can't remember what the number is now, but there's nationwide, there's not a whole lot of appeals, estate and gift tax appeals officers. And so they have lots of cases. Again, very sophisticated. They know their stuff. Their whole job is to try to resolve. There's supposed to be a new set of eyes. Their whole goal is to resolve cases and to settle cases. And then third, you can deal with IRS counsel if you can't settle with appeals. And there's different ways to get there to appeals. You can go straight to appeals. You can file a tax court case and then get back to appeals. But there's different things to do. But the vast majority of cases, the vast majority of them settle. I mean, I would say 95% of the cases settle. Because what you're trying to do is show the IRS they have risk. And we already know we have risk in a lot of cases. And so the question is, how do you balance that risk and come to some sort of resolution at that point?
At that point, have you usually filed an estate? You've filed your estate tax return. You've probably paid some, because at that point, in most of these cases, you had some amount of tax you owed. You've just lowered the potential value. And so they maybe are arguing with you on the total tax owed. Is that usually the case? Or
that's exactly right. They're saying your value was too low. Our value should have been here. And so we should have paid more tax at that point. Now, the good thing about this is my fees for an estate tax case are deductible at this point. So I love going in and saying to the IRS examiner, let's go fight about this because you're paying about 40% of my fees. And my client's very happy about that. So it's all deductible. It's a funny thing to do. They know I'm going to come in and do it. So any of my fees are going to be deductible. And the other thing is, and this is where it gets complicated, is you're going to pay, let's say we settle and you're going to pay additional tax. Well, there's going to be interest on that. But that interest is deductible to the estate. And so you have to do this circular calculation when you're doing this. And so this number that they end up, we're just using round numbers of $1,000 of additional tax, because there's interest on that, you get a deduction for the interest, it reduces that $1,000. It's a quirky area of the tax law, the estate and gift area is, just because it's very unique on how it works.
In the estates that are like maybe in that 26 to 28 million range, we'll say for a married couple, and they were able to avoid estate tax. Do you see many IRS audits or many where they're coming in and saying, you were right underneath?
You see them every once in a while. We don't see them as much as I thought we would see them, frankly. We don't. Now, what I've seen, and you're talking about just below the exemption amount, which I think we're all now agreeing it's probably going to stay at this 28. They'll come and look at them every once in a while, but something's going to have to cause them to look at it. Not just a valuation. There's going to be something that's going to cause them to look at it. We don't always know what that is, but every once in a while we will see something like that. The one thing we have seen in the last 2 years that I've never really seen as much anymore, but I hadn't seen as much, they're actually doing gift tax examinations. I'm just surprised they're doing as many gift tax examinations as they're doing at this point. Again, a lot of it's valuation issues.
And so is that because they're seeing gifts that someone's labeling the value, maybe they're gifting stocks or company value or something like that, and they're saying, the value is actually much higher? Is that the case you're seeing?
Yeah, I mean, they're trying to, a lot of what estate planners are doing right now have been doing up to this point was saying this large exemption amount, estate tax exemption amount is going away at the end of 25. As we just talked about, that's probably not going to be true. But a lot of people are doing planning to take advantage of that, and we're doing gifting to take advantage of this high exemption amount. The question was, if you're giving that away, we tell clients, you can give away $40 million of assets, and we can probably get it discounted down to below $28 million. And That results in significant amount of savings for you. But the IRS challenges that and says, no, that wasn't $28 million. That was a $35 million gift, and so therefore you've got some gift tax that's going to be due on that additional amount.
Now, obviously your goal is to help clients know what they can do so that they don't have to be fighting the IRS. Like, what are either some of the red flags, or what are some of the ways that they can prep their estate so that they don't have to deal with this?
Well, don't have as much money. That's the easy answer, right?
Give it to charity. Put it into a foundation. Yeah.
Yeah, that's it. That's the easy thing. Give it to charity. You're not going to owe anything at that point. It's hard to say what red flags are because on the income tax side, it's easy. You pick out home office, things like that. On the estate tax side, it's not as hard to figure out what those are. It gets back to the same thing, which is, are you, when you prepare and file the 706, do you have all the information they need? Are you taking a position on there? Do you have everything that can back it up? On the gift tax side, have you attached everything to the return itself? Because that's going to be very, very important. But red flags at this point, it's really hard to say there's red flags in the estate area just because it's a pretty straightforward estate tax return on what you have to have on there. And you're going to have to show your discounts on there.
Oh, you put the value, you say, here's what market value.
A lot of times you're going to attach the appraisal, and the appraisal is going to show on there what your discount is. And a lot of times, if somebody were to look at that and you have a 75% discount, that's probably not going to fly, and somebody's going to pick that up and look at it. So those are the things that I think probably cause the most problems for people. Or let me throw another one at you. A 3-page appraisal. I mean, if you got a 3-page appraisal, that's not going to do it. You've got to have a good, solid, from a good appraisal that you need to attach.
I was looking. Obviously, this is outside of a state, but I was looking at a conservatorship the other day, and they sent me the appraisal that they had got as they were using in court, and it was like, 3 pages on a property, and everything was just boilerplate language. Like there was really nothing.
Yeah.
And I thought, I was like, this, like. I don't think this is going to work. I don't think, but I mean, in certain legal contexts, maybe you can get away with that. I totally understand though, when you're like, oh, you went with the cheap guy. You were like, and I used to get calls 15 years ago. People would say, I need a probate value at time of death. Right. And so, and people, like, do you know, am I a specialist in this area? Do you know if I'm good for this? Like, no, it's okay. We just need something on paper, put it on letterhead, and we'll submit it. You're like, I don't know if that's sufficient enough for, but yes, I totally understand that. So what are some other stories you have that would serve as warning to people who are going into these sorts of situations?
Well, I mean, again, I think it's a lot about prepping. It's things like when you're doing your planning, have you written, like we talked about, have you written everything down? Is there follow through on the things that you need to do? I tell people, if you made a gift, have you filed the gift tax returns? And when you file the gift tax returns, have you made adequate disclosure on there so it puts the IRS on notice? Because that starts the 3-year statute of limitations on that gift tax return. If you haven't made adequate disclosure, and there's a case out there recently that discusses what adequate disclosure is, so that you do that and you start that and that 3-year statute starts. Because if you haven't made adequate disclosure, or if you haven't filed the gift tax return, then all of a sudden they can open up and look at that gift and go back to that even if it's more than 3 years ago. So that's going to be extremely important.
What's the size of gift that triggers the need for a gift tax return?
Anything in excess of, I think it's $15,000 for this year. It's that. Anything above that $15,000 per person, per spot, those kinds of things is going to require one. A lot of times we will do a gift tax return just to start the statute of limitations, even if we don't think there's an issue there, because maybe we think the value is down below that you have to file one, but we'll do it to start the statute, disclose everything, and just let that run. Because again, while the IRS has picked up more gift tax returns in the last couple of years than they had before, I still think it's good to get that statute going, and if it's gone, it's gone. The IRS can't do anything about it. I had a case years ago where they took a position that there was no value to the gift that was made because of certain circumstances, but they didn't file a gift tax return. And so when the decedent died and they were looking at this, they said, well, you didn't file a gift tax return when you made this back then, so there's no statute of limitations. We're going to look at that transaction also. So starting that becomes really, really important on the gift tax side.
Well, and I think a lot of people don't even know, gift tax rules. Some people aren't thinking about taxes every day. If somebody is going to be underneath the lifetime exemption, underneath what we talked about, the 14, 15 million per person, do they need to be filing gift taxes if they're giving more than $15,000 a year?
Yes, they do. Well, if you're giving more than $15,000 a year, obviously it's going to eat into your exemption amount. I mean, it's going to pull away from your exemption amount. And the answer is yes. My answer to these is always yes, and because you never know when you're going to win the lottery. And so you win the lottery. It's kind of when you file, when the spouses when they're not going to be above, they don't think they're going to be above 28 million. But we always tell them, you want to go ahead and file the return just in case something were to later beyond, you're going to be beyond the $28 million, and you want to, you don't want to waive anything at this point. And so filing those returns, I think, is important. I think it's always important to at least sit down and discuss it. Saying you need to do it, again, depends on your facts and circumstances, but talking to somebody about it to go, okay, let's think through this. What do we think we need to do? And does it make sense? What are my options? And so talking to somebody about it, I think, is really, really important.
When we think about like being underneath the thresholds, I see people all the time gift children large gifts, right? And they're probably going to be underneath the thresholds. They're not going to be above the 28 million. So I don't know if it'll ever trigger in the IRS's mind that, hey, there might have been, we need to make sure we're dealing with this. We need to make sure there's, but I just was curious if the IRS was paying attention to that, and I think probably the legal requirement would be, yes, you need to file this. The IRS would like to know.
But again, we just don't know where you're going to end up. You're gifting right now, and 10 to 15 years later, your estate's significantly higher than you thought it was going to be, and all of a sudden, we should have been doing some things back then. That's where the backfilling comes in. It's when that happens, and you go, okay, well, let's go back and fix the problem. I mean, and sometimes you just need to do it.
Are gift tax returns the same as amending returns? Like you can go back a certain number of years
to amend them,
or not just to amend them, but to file them. Like let's say,
oh yeah. If you haven't filed a return, then you would need to go ahead and file it, because that statute of limitations stays open until it doesn't start until the return's filed.
Even if the return should have been filed 7 years ago. So you could go back and say, well, I actually need to go clean some stuff up. I'm going to file one for 7 years ago, 6 years ago, 5 years ago, and then your statute of limitations starts for all those right now or whenever it's filed. Okay.
Yes. Yeah. We had one recently where we were going back 14 years because the return is filed. We were taking a position on a very interesting estate and involved a gift made years ago, and we were trying to figure out how to do it. And so we were taking a position that required us to go back and amend this return and claim a gift was made back then. So we amended that return that was 14 years old on a gift to include these additional gifts, just trying to kind of fix those kind of problems. And it was another one of those cases where we said to the client, okay, we're going to put you in the best position so that we have an argument with the IRS. We can't go try this case. We're going to put you there. We're going to take a position. They may argue something else, but we have alternative ways of discussing this. And this gift tax return involved doing that and putting them in the best position.
And in that case, I guess you had to go back and get a valuation for 14 years ago then.
We did. It involved oil and gas properties. It involved timber. So this wasn't a small task to go back in and do all. We had to get all these appraisals. And they had to go back 14 years. Our appraisers did. They were very good. They knew what they were doing, but they had to go back. And that's the other thing that I always try to tell people is, you get an appraisal, read the appraisal. Sometimes the appraisers have the wrong facts in there. And boy, I've seen that, and that will come back and bite you really, really hard.
Once that's been filed where the valuation from the appraiser is attached to that tax return, is it easy to amend and change those things if you see an error?
Not so much.
They're like, well, this is what they said. This is what you filed. It was pretty. It's in the record now.
Yeah. You can go back and fix, but so people ask me, what's a red flag? Amending a return can be a red flag. And so that's one of the things we always take into consideration is, what do we think is going to be the impact of doing that? Does it make sense? Does it not make sense? It's the same thing you're asking about other things that people should do when they're doing their planning is, read your documents. Make sure you understand what they say, because you need to understand what you're doing here so that if you ever have to explain it to somebody, you can. I've had too many clients being interviewed by or being in a deposition trying to explain a transaction and said, well, somebody drew some boxes and some arrows and some circles and some squares, and they told me it worked, but I'm not sure exactly how it worked. That's a bad thing to have to happen. So go back and read those things. And again, I think on the appraisals in particular, make sure the facts are right. Just make sure the facts are right.
Now, you do a lot of presentations to industry professionals. You teach them about these things. What are the tips you give them? Like, you've got maybe a checklist of things they need to be thinking about, both advising their clients and...
I got a ton. Yeah. I'll tell people all the time. I can sit there and go through things like, look, make sure, like I said, gift tax returns have been filed. Make sure the entities are all in, that you had this great planning, but let's make sure the entities are in good standing. Let's make sure they're continuing to be in good standing.
Entities in good standing is entities in good standing might be filing franchise tax returns or making sure your
Exactly.
LLC is still active, not,
all those simple things that need to be done on a regular basis. Are in a typical planning, let's say we're setting up a family limited partnership and mom and dad are gifting. Are mom and dad retaining enough assets to live on, or are they got to live out of the partnership? We don't want to live out of the partnership. If we're going to make distributions, make sure you're making distributions to all the partners, not just to mom and dad, those kinds of things. We want to respect the legitimacy of the entities themselves so that it doesn't look like we did planning, to put it to the side, and then all of a sudden you said, we're just going to do the same thing we were doing before. You want to respect the legitimacy of all those kinds of things. We talked about earlier, have you documented the non-tax purposes for doing the planning you're doing? Have you done that so that you have to explain it? Because you got to have non-tax purposes. Has there been adequate full consideration? Have the actual transfers been made? You're transferring an entity into a partnership, but you actually never make the transfer into the partnership. You're transferring something into a trust. All the documents say that, but nobody actually went in the records and transferred the asset. That would be nice. Things that are simple to do. And how about, I always like this one, how about we actually set up the trust before we transfer the asset into it? I mean, I've seen situations where the transfer date is this and the trust is set up 10 days later, and you go, now how does that work? I mean, come on, guys.
Is there any legal issue? I mean, obviously that's not good paperwork, but does that create a legal nightmare?
It creates a problem. What I'm trying to avoid is giving the IRS any kind of thing that they can hang on to and say, oh, look, you guys, this was not any of this legitimate. You guys didn't even follow the procedures for doing this correctly. If you were trying to achieve these non-tax purposes, look what you did. I mean, come on. And so those kind of little slip-ups here and there give the IRS a toehold on something. They just give them a toehold that they can hang on to and point a court to. There's a case out there, I'm trying to remember I can't remember the name, but there's a case out there involving somebody who was transferring stock in a company. And it's a reported case. It's settled. It didn't get tried. But one of the things the IRS was pointing to was, yes, you were saying this is what you transferred, but you treated it in such and such a way. You did this on a transfer, but you treated it in such a way. Giving the IRS those toeholds of not following procedures, those kinds of things, you just don't want to do it. But again, you become the low-hanging fruit for them, or at least give them that toehold that they want. I mean, things like you transfer an asset. Your family has a house in the mountains. They decide they're going to transfer it into another entity, a partnership or a trust or whatever. But we're still having personal use of it. Are we paying for that personal use? How are we handling all those things? All those little things that nobody really thinks about until they get to me and I go, yeah, we should have thought about that at the time that we were doing it. But, again, we try to go back and fix those things as best we can. So those are some of the things they need to know. I mean, as far as dealing with the IRS, I can tell you this. The best thing you can do is try to, again, not to be the low-hanging fruit, but make them go through the steps of what they're going to do. If you got a weakness in your case, if you think the IRS is going to find out about it, do you tell them that we got a problem here? That's a judgment call on things like that. In estate tax cases, you can't extend the statute of limitations, so understand when the statute runs and the pressure that's going to be on the examiner. They got 3 years from the date the return is filed, so know that that's going to be a pressure on them to do something one way or the other with respect to it. There's just lots of different things we can do on trying to work through. And these days we're dealing a lot of long-distance relationships with the IRS. They don't travel as much. They're spread out across the country. It's a different kind of relationship that we have with examiners. We used to have examiners here that we would talk to on a regular basis and we could see. And now you don't get as many. You kind of spread across the country. Finding the right person to handle that for you is going to be very, very important.
Now, at what point in a problem or in a case like this should someone be calling you? Like, when's the best time to reach out to you? Or what are the different options when people reach out to you?
If we're doing the planning, usually our plans don't have as many problems, I can tell you. I've never actually had to defend one of our plans. But the best time is early on, before the Form 706, the estate tax return is filed, because we need to look and see, do we need to go back and backfill? Are there some problems we need to address? I mean, it'd be better if after the planning was done, before everybody's dead, that we've looked at everything and make sure the documents are done. I'm assuming that somebody, the estate planner, has done that and they've made sure the client's got the follow through, or the CPA has, or the financial planner has had the follow through on that and made sure that they've done what they're supposed to do. Maybe that's when you want to get us involved, because we want to make sure that before this plan really goes into effect, over the last 3 or 4 years, we've done the right thing. I've gotten involved when we're going to take a position on the return. We've got to figure out how to file this return. I've gotten involved after the return is filed and the IRS showed up. The earlier the better, frankly, just because we can take a position, put us in the best position we can. Like we talked about, those ones where we said, we can't fix these problems. Let's go fix as best we can. So when we get to the IRS, we've now put us in a position to make the best argument we can.
That's awesome. Now let's just switch for just a second. I like when we think about some of the other advisors because you may be just dealing with the IRS directly, and you might have your team might have done the estate plan, but there's also the CPAs, the financial advisors, maybe another attorney that was doing the plan. What advice do you give to them in helping to advise their clients or prepare their clients for these things, or anything you say to those different specialties?
I always, my pitch to them always is, let's make sure we're always checking back with the client. Let's see what life changes have come about. Look, everybody's part of the team. Let's make sure that we understand what the team is doing, so that if a client gets divorced, if we've had some event that's gone on, that we know to go back in, we've got this planning, and don't just ignore the planning. On a yearly basis, somebody should be going in and looking and seeing, is there something here that needs to be changed? Is there something here that we need to make sure the client's doing? In the case of the CPAs, I generally say, you're probably the front line on this. You're probably the person who's going to be making sure that all the returns are filed, all the books and records are properly kept, all those kinds of things to make sure that's done. And so doing that on the front end is going to help on the back end a lot. And I just tell them, you've got to pay attention. You can't just assume, I think you said it earlier, estate planning's done, you stick it in a corner and, well, we'll go look at those documents when mom or dad die at this point. You got to kind of, I like to say it's almost kind of a living document in some ways. You've got to go back and check it. Yeah, do we want to do that? Those kinds of things, and making sure, do we want to have these people be the trustees? Do we want this person as the executor? We don't like that person anymore. Maybe we don't like that person anymore. We've got a falling out, so we don't want them being the executor. I mean, things as simple as that need to be looked at a regular basis. That's a big
takeaway for me, is that the estate plan is a living set of instructions, and that oftentimes one of the biggest mistakes people make is not actually executing the instructions. Like, we got the plan, but I didn't know we had to do anything else. And it's just a good reminder that as we're talking with clients, like, let's make sure that we did all the pieces that the attorneys set up. It's not just a once and done. It's both an ongoing check back and also making sure you got the documentation going.
It falls back on the estate planners too, because the estate planners on a regular basis should be checking with the client. I mean, saying, hey, is there anything to change? Has anything changed in your life? You got more kids? You got grandkids? Do you have adopted kids? I mean, all those kinds of things. And what life changes? Have any of your kids gotten a divorce? Do we need to be thinking about those kinds of things? All those kinds of life-changing events. Have you sold your business? Hopefully the estate planner knows about that. You and I both have seen circumstances where the client will, I'm selling my business and it's about to happen, and we're going, wait, hold, we were supposed to do there's some things you could do ahead of time for that, and we should be doing that. We should have been doing some gifting of some interests and those kinds of things. We see it a lot these days, because people are selling their business because, I was never going to sell my business. I'm going to do it. But somebody comes in with an offer they can't refuse. And so they go. And it's too late to do some of the things that need to be done. And it's the same thing with estate planning. Do some things now ahead of time. Pay me now or pay me later kind of thing.
Now, if people want to connect with your firm, tell us your website. Tell us where they can connect or how they can connect with you.
Sure. So the website is Meadows Collier, MEADOWS, Collier, COLLIER.com. It's meadowscollier.com. And our general number, I give you that. Our general number is 214-744-3700. And feel free to reach out to us at any time. We're happy to talk to you. I get calls from, I don't get calls from clients very much. I get calls from CPAs, financial planners, and other attorneys asking me questions, and that's fine. I don't have a problem doing that. I try to answer as many can. We have our own blog. We actually do these too. We do webinars, and we do podcasts and things like that. I'm happy to answer questions where I can. I get calls a lot of times. People go, well, what do you think about this? And I'll give them my 2 cents on it a lot of times. So I don't mind people reaching out to me at all.
Well, I really appreciate your time on our podcast today, and we'll connect with you soon. Thanks, Joel.
Sounds great. Appreciate it.
That's it for today's episode of the Wealth Transfer Podcast. If you found value in this conversation, would you would you leave us a review? That would be just so honoring to us. We'd appreciate it. And if you know somebody who might need to listen to this because they're thinking about their next chapter, will you send them a link to this podcast or this video so that they can listen more as well? For more episodes and expert insights, be sure to follow and subscribe. That means the most to us. Follow and subscribe, please, please, please. And when you're ready to take action on your own real estate plan, or if you need help with wealth transfer planning, we know a number of experts in all the different spaces, and we'd love to connect you with them. You can reach out to us via direct message or comment. You can email us, matt@templeton.realestate. No .com, just templeton.realestate. And I'd be happy to connect you with an advisor. Thanks so much.